Welcome to the second FCI webinar, Forest and Communities Initiative webinar. Bienvenidos a todos a la segunda edición del webinar IBC, Initiativa Bosque y Comunidades. Bienvenue à tous pour la deuxième édition de webinaire FCI, l'initiative Forêt et Communauté. J'espère que vous pouvez tous voir mon écran. I hope that everyone can see my screen. As per the screen is actually saying, so a translation is available in English, so please choose the relevant channel in the interpretation facility as highlighted below on the screen. Una traducción está disponible en español. Por favor, escoja el canal indicado en las opciones de configuración. Une traduction simultanée en français est disponible. Merci de sélectionner le canal approprié pour votre traduction. So I'm going to switch to English. My name is Prune Zunino, and I look after the Forest and Communities Initiative at Prince Albert II of Monaco Foundation, together with Lina Hansen, who's initiative coordinator, who's by my side. So what is FCI? Just really briefly, as we mentioned it on the first webinar, so the Forest and Communities Initiative's primary mission is conserving forest through empowering communities. In other words, it promotes forest protection through the action of indigenous people and local communities, also known as IPLCs. On the behalf of the 5 FCI partners, being the Prince Albert II of Monaco Foundation, together with the IUCN, World Commission on Environmental Law, the International Ranger Forest Federation, the Global Forest Coalition, and the International Indigenous Forum on Biodiversity, it is our great pleasure to welcome you to this webinar. As you know, following this, your registration, this is the second of a series of 3 webinars that will inform our first FCI conference to be hosted in November by all the FCI partners in Monaco. Last time, we addressed 2 topics, which were effective forest conservation methodology for IPLCs and the topic of right-based and gender-just approach in forest conservation. We're very proud on this first webinar to have reunited more than 70 people from 49 different countries. And it's been a good start for our first webinar. We thank you very much for those who have already provided some feedback via our feedback form. For those who haven't yet, we are looking forward to receiving it. Please note that for those who could not join, we are currently looking into having the recordings made available on the website. And we expect those to be available when all the webinars will be finished. In today's webinar, we will look into the role of law in forest conservation. As per the communication in our meeting invitation, we had a change in the initial plan related to the topic of reconnecting national and international funding and the governance to IPLCs for forest conservation. This will therefore be discussed on the last FCI webinar on the 27th of April next week during the first hour, and the second hour will address the 2 products that we hope to release in November, being the Grassroots Toolkit and the Policy Brief. Our discussion during these webinars will help us define these deliverables. Be assured that we are not looking at reinventing the wheel, and your experience and expertise will be absolutely crucial to ensure that these products will be as helpful as possible. Now that you know about the dates and the deliverables, in terms of the format for today's session, we therefore have an extended time for this topic of the role of law in forest conservation. So please expect about 40 minutes of a panel discussion, and which will leave 30+ minutes for questions and open conversation, together with ideas to be raised by all of you, our dear participants. We very much look forward to your participation. Before we start, like last time, I just would like to set a few easy rules to follow during this webinar to ensure that we have a productive session. First, choose the channel The first, as mentioned earlier, please choose the channel, the appropriate channel for your translation. This webinar is translated into English, French, and Spanish. And you can choose the appropriate channel in the interpretation function below, as previously mentioned. Secondly, please turn your microphone off whilst you're listening. We will be turning your microphone off when a background noise is being heard, just to make sure that the conversation with the panelists is not being disturbed. Finally, following the panel discussion, we will be encouraging you to actively participate. You can write your questions directly on the chat section on your right, so feel free to do so whilst the panel is actually speaking, and we will take them once the floor is open. Otherwise, you will also be able to ask your question orally directly to our panel. Before doing so, please raise your hand and introduce yourself, giving your name, your country, and the organization you represent. Now, with all of these information, I would suggest that we just start our topic. Christina, can I leave the microphone to you?
Absolutely. Thank you so much, Prün. Well, on behalf of the IUCN World Commission on Environmental Law, it's a great pleasure for me and a great privilege to welcome all of our speakers and all the participants online to today's webinar on the role of law in forest conservation. My name is Christina Voigt. I'm the chair of the IUCN World Commission on Environmental Law, and I'm a professor of law at the University of Oslo in Norway. WCEL, the World Commission on Environmental Law, is a very proud partner together with the other partners in the Forest and Communities Initiative, and we're very much looking forward to the upcoming webinars as well as the international conference towards the end of this year. Before we start delving a little bit deeper into today's topic, I would like to use this moment to express some words of thanks. First of all, to you, Prün. Prün is project officer at the Prince of Monaco Foundation, and together with Roberto Cole, who is also online, who is the executive officer of the IUCN World Commission on Environmental Law. Those two have been instrumental in getting together the speakers and the program and everything that we're going to hear here today. My thank goes also to Justice Herman Antonio Benjamin, and I'll introduce him in more detail later, but Justice Benjamin is the mastermind behind today's program. Now, going towards the topic of today's webinar, the role of law in the conservation of forests. We know that forests are the home of millions of people worldwide, in particular of indigenous peoples and local communities who live in and from forests, many places on this planet, and who have been the guardians in many places for forests. Forests are also the home of most of terrestrial biodiversity, and many places also hotspots of biodiversity. But forests are also important for the global climate system due to their capacity to store carbon dioxide in their biomass and soil. And we know from the latest report of the Intergovernmental Panel on Climate Change that we have no chance of reaching the Paris Agreement's goal of holding warming close to 1.5% without conserving the forests that we have against the threats which are put to them. And yet, yes, forests are under threat. There are several objectives that meet each other's, in many cases collide with each other when it comes to forests. There's the need for agriculture and for development, agricultural expansion in terms of cattle raising or soil plantations that in many places impact on existing forests. There's the need for food and feed products, but there's also the need to conserve forests and to protect the people and the biodiversity within them. There is the need to protect the knowledge and the rights of indigenous peoples, and all these different objectives meet each other when it comes to forests. And it is in this very complex picture that the role of law becomes apparent, where the law plays an absolutely crucial role in conserving forests, because it is only through appropriate legislation, through laws and acts, that the long-term sustainable and systemic conservation of forests can be ensured. Because otherwise we risk short-term interest to take over when it comes to forests. But those laws have to be designed very, very carefully. And where they are designed carefully, they also have to be implemented effectively and enforced with. Those laws have to be considered of transparent and effective and inclusive forest governance structures. Laws need to protect the rights and knowledge of indigenous peoples and local communities. They also have to clarify and protect land tenure. In many places, laws or legal changes first have to chart land tenure to identify who has land rights to particular areas. Laws also have to ensure that biodiversity is conserved against all sorts of interests against it. The legal framework has to be designed in a way to avoid reversals and displacement or leakage of emissions, as well as people, where one project, one place can look very positive, but it leads to displacement of people or of emissions or biodiversity to somewhere else. And finally, and that list is not exhaustive, as we will discuss today, the legal framework has to ensure the full and effective participation of all relevant stakeholders, in particular indigenous peoples and local communities. Now, to discuss the role of law in the context of forest conservation, we have today a wonderful expert panel that will share with us their expertise and research in the area of legal protection of forests. The panel will be moderated by Ambassador Patricia Lima. She is Ambassador of Brazil to Cameroon. And the speakers that we have lined up here today consist from different backgrounds, different expertise. We will start, or I guess we'll start with Justice Antonio Herman Benjamin, who is Justice at the National High Court of Brazil, and he is the chair of the task force on a Model Forest Act under the IUCN World Commission on Environmental Law, and task force who looked at how can laws effectively and appropriately and fairly designed in order to protect and conserve forests. We also have Professor Eeshan Chaturvedi. He is Associate Dean at the Jindal School of Environment and Sustainability in India, and currently a Ph.D. student at Stanford University. We further have with us Dr. Kenneth Angu. He is the IUCN Regional Forest Program Coordinator for Central and West Africa and heads the IUCN Cameroon Country Office. We are joined by Alejandra Rabasa Salinas, who is the head of the General Unit of Scientific Knowledge and Human Rights at the Supreme Court of Mexico. And last but not least, by Professor Andrew Heinrich, who is an adjunct professor at Columbia University and the president of Project Rousseau. We will also receive concluding remarks from Mr. Ayman Cherkaoui. Ayman is the director of the Hassan II International Center for Environmental Training in Morocco, and he is also the deputy chair of the IUCN World Commission on Environmental Law. And without further ado, I would like to give the floor to Ambassador Patricia Lima, who is here with us. And we are very, very grateful to you, Mrs. Ambassador, for setting aside your time and your energy to be with us here today. It's very much appreciated. And with that, you have the floor.
Thank you, Christina. Thank you, my beloved friend Herman Benjamin, for the invitation. It's a privilege to be with such a special group. And what I observed is that forest is really a leading movement almost, because we have people here at the panel, and I observed through the chat from all continents. So it is a common motive of preoccupation of all people nowadays. We have people from Pakistan, we have people from India, we have people from Brazil, we have people from Mexico, from Paraguay, everywhere. So this is very good for the reason that we are discussing here today. It's our core theme, forests, and how can law help, mobilize people and give the marks for common action. I think dialogue has been going on for a long time related to forest, to preservation, conservation. And in Brazil, we are mobilized as well. And I imagine in many countries, as you represent here, as you are representing your people and governments here today, we are very much concerned about the effects of protection of forests in the future. What is the impact, the social, political, economic, financial, developmental impact of forests in our societies? And it's very important to discuss, to establish channels of dialogue. We have already some on their way, and we have a new, as we are trying to establish a new and positive channel of dialogue, of conversation between Brazil and Cameroon. We have COMIFAC in Cameroon, and we have other institutions that are also dialoguing, having dialogues with COMIFAC, so that we can have Cameroon and other countries from the Congo Basin also mobilized in the dialogue towards a legal framework for forests in Africa. This is very, very positive. There is someone from Hawaii. You see the amplitude of our dialogue here today. This is very, very positive. I will not take long in showing the importance. That's why we are here today, because we think it's important, and we think it's important to discuss and to establish bonds between those people who can make changes in the treatment of forests in their own domains, in their different domains. Since Christine pointed out, due to some urgent engagement, I will give the floor to Justice Antonio Benjamin so that he can start the participation of the speakers here today. Mr. Herman, you have the floor.
Thank you, Ambassador Patricia Lima. Let me begin saying that it's a great pleasure to participate in this event organized or co-organized by the Prince Albert Foundation and the World Commission on Environmental Law of IUCN. And I'd like to thank the organizers, especially Prune Zunino, who is here with us, and Professor Christina Voigt, and the whole team that is behind this event. I only have 7 to 10 minutes. It's not much, but perhaps we could begin stating 1 or 2 very obvious aspects of the legal protection of forests. And in order to do that, it would be helpful to compare it with the protection of wildlife and the protection of the climate system. The first obvious point would be to say that it seems easier to protect forests vis-a-vis wildlife and the climate system because forests couldn't be more visible. They are there. As opposed to wildlife, all of us have experience in going into wildlife watching and not seeing what we intend to see. And then in the other extreme, we have the climate system, which is this gigantic, global, intangible thing that law has to address as well. So it is just obvious that to protect forest seems to be easier than protecting wildlife and the climate system. But this is very misleading because forests can be absolutely diverse. In a single biome, we might have different ecosystems that are in dialogue, and law needs to take this into consideration. And forests are, especially tropical forests, that's our focus here today, have people that depend on the integrity of the system. People that have lived, I would not say in harmony, but in cooperation with those forests for ages. Another aspect or level of difficulties is that, as opposed to the old regulation of forests already in the 18th century, the 19th century, we cannot see forests as a local legal issue. And this creates complications for judges because judges are territorial. I have my own jurisdiction. It's usually a city with a large city with village around. Some courts have national jurisdiction and very few courts have international jurisdiction. And those that have international jurisdiction cannot apply or protect forests per se because of a lack of an international regime for the protection of forests. Therefore, it's misleading to think that it's easier to protect forests, and especially tropical forests, as opposed to wildlife, water, and climate, the climate system, just to give you some other areas in which environmental law is so relevant. That said, let's move to what can be done and what is being done. And we begin with the recognition of the fact that there is not, as opposed to other areas of environmental law, we don't have an international legal regime for the protection of forests. This is probably, together with coral reefs, the biggest gap in international law in respect to the elements that compose what we call the environment. Second, it is important to recognize that it's not enough from a planetary perspective to protect one single biome of tropical forest and forget the other ones. And we are lucky to have here the three, should I say the four biggest tropical forest biomes of the world. We have the Amazon, we have Central and Mesoamerica, we have the Congo Basin, and we have the Indo-Malaysian tropical forest biome. If we really want to protect tropical forests, we have to protect all of them. The focus in my region, for example, is on the Amazon, and we tend to forget the rest of the world. And I'll return to this in my concluding remarks. So, based on the fact that we don't have an international legal regime, but we do need to protect all those tropical forests of the world. The question is, what can we do? We could say, one, that even if we had an international legal regime, that would still not be enough. Because at the end of the day, forests and wildlife are protected by national courts and by national authorities, subnational, even local. It's also relevant to say that recognizing that we don't have this international legal regime and recognizing that the legislation of the countries that make up each one of those biomes, tropical forest biomes that I have mentioned, have to some extent national legislation protecting those forests, that those laws tend to be very different. And in some parts of the world, those laws have been inherited. The ones that exist, they have been inherited by the colonial or from the colonial legal framework. And the colonial forest protection framework is, to a large extent, based on the protection of temperate forests. So to begin with, there is a foundational ecological mismatch between the type of biome that needs protection and the origin of the legal framework that is put in place. The other point that I could highlight here is that law by themselves cannot protect tropical forests. We need laws in combination with the institutional framework. Strong and independent forest agencies, the so-called administrative state, strong, independent, but also with integrity, judicial system, and the integration among the countries, the legal systems of that particular biome. So that's why, as Professor Christina Voigt alluded to, WCEL, the Asian Development Bank, and other institutions, the Global Judicial Institute on the Environment, are moving with this new initiative that is called a Model Forest Act for the world, which is basically a long process. We envision this to take at least 5 years. The first segment of 2-3 years just to draft what would be the general part of this Model Forest Act that could be then used by countries as a supermarket, a legislative supermarket shelf. Go there, see what their needs are, what they like, what would, in their view, work in that particular biome, and facilitate the work of legislators in either drafting new forest legislation or reforming existing forest legislation. And finally, and I think this dialogue here is just the beginning, I hope it's just the beginning, a dialogue among those biomes from a legal and policy perspective, not just looking at forest protection, but the protection of indigenous people as well. So we can learn from each other, learn from our mistakes, learn from the things that we have done right, and then better protect the tropical forests of the world. My time has ended. Many thanks.
Thank you, Justice Herman Benjamin, for your wonderful intervention. I will now pass the floor to Dr. Alejandra Salinas. Let's hear from her. And well, you have the floor, please.
Muchas gracias, embajadora Lima, por recibirme aquí. Muchas gracias a Christina Voigt también por siempre organizar este tipo de eventos progresistas increíbles desde la Comisión de Derecho Ambiental Mundial, al ministro Benjamin por también siempre tomar el liderazgo para no dejar de estudiar y de cuestionarnos cuál es la contribución que los sistemas de justicia pueden hacer a la protección del medio ambiente y en este caso el tema fundamental de los bosques. Me da mucho gusto estar aquí y me da mucho gusto hablar después del ministro Benjamin, porque justamente lo que yo quería platicar parte de retomar una idea que él acaba de decir, que es que las leyes por sí mismas no van a lograr la conservación de los bosques y de las selvas y de los recursos forestales. Yo vivo en México, trabajo en México, y en el caso de mi país, la legislación forestal ha estado reformándose continuamente y hasta hace muy poco una de las principales reformas que se han hecho a la legislación forestal fue justamente para incluir un capítulo de salvaguardas para proteger los derechos de las comunidades indígenas y de las comunidades agrarias y de las comunidades rurales. En México, más del 80% o el 85% de los recursos forestales y de los bosques son propiedad de comunidades indígenas y originarias. Y hasta hace muy poco, la legislación ambiental y forestal no reconocía sus derechos de propiedad y los derechos que tenían que garantizarse en el uso de los bosques para hacer compatible la protección de los usos culturales, el derecho a sus medios de vida, etcétera. Y ahora la legislación forestal mexicana incluyó, por ejemplo, como salvaguardas el consentimiento libre, previo e informado de las comunidades agrarias y los pueblos indígenas en cualquier decisión que involucre el uso de los bosques, la distribución equitativa de los beneficios de cualquier persona que utilice recursos forestales genéticos, maderables, no maderables, estableció que deben hacerse esquemas legales de certidumbre y respeto a los derechos de propiedad y posesión legítima y garantizarse los derechos fundamentales de acceso a la información, a la participación pública y a la justicia a través de mecanismos que no me da tiempo de abordar, pero son muy puntuales para poder compatibilizar disposiciones de conservación como todo el sistema de permisos para hacer cambios de uso de suelo forestales, subordinado, por ejemplo, a la conservación de los recursos hídricos y el hábitat de especies en peligro de extinción. El permiso para el cambio de uso de suelo forestal en México requiere demostrar que no se van a afectar especies en peligro de extinción ni su hábitat, ni comprometer la captación de agua, que puede verse afectada si desaparece un bosque o una selva. Pero más allá de la legislación, yo quiero enfatizar en estos minutos que creo que una de las contribuciones más importantes para la protección de los bosques en los sistemas de justicia está ocurriendo en muchos lugares del mundo, incluido México, por supuesto con el liderazgo de Brasil, en la corte del ministro Benjamin, a través de la adjudicación, a través de la interpretación judicial y la reinterpretación judicial de los principios clásicos del derecho ambiental que ahora pueden utilizarse de una forma que va mucho más rápido que el desarrollo de la legislación. El ministro Benjamin ya mencionaba que no existe un instrumento internacional para la conservación de los bosques, por ejemplo. Y muchas leyes de la región no se han reformado para cambiar esta perspectiva colonial de la que él hablaba. Pero a través de los fallos de los tribunales, a través de la jurisprudencia, se está dotando de un nuevo contenido a las constituciones, a los tratados internacionales, para poder realmente hacer una diferencia a través de la aplicación de la ley en la conservación de los bosques y recursos forestales. Dos ejemplos muy particulares quiero poner. El desarrollo de dos principios que se han introducido a los sistemas de derecho ambiental a través de las Cortes. La función ecológica de la propiedad, donde el ministro Benjamin ha sido un pionero y ha inspirado jurisprudencia en muchos otros países como en México, donde la Suprema Corte de Justicia de la Nación ha resuelto que cualquier actividad que pueda afectar un bosque, una selva tropical o un ecosistema forestal, incluyendo los manglares, no importa de quién sea la propiedad, si es propiedad pública, privada, social, tiene que respetar el principio de la función ecológica de la propiedad, que implica que cualquier uso de la propiedad no puede fragmentar la integridad funcional de los ecosistemas, su potencial de captura de carbono y los servicios ambientales que el ecosistema presta. El principio indubio pro natura es otro ejemplo del desarrollo judicial y de las contribuciones que puedan hacer instituciones como la Comisión Mundial de Derecho Ambiental para ir avanzando, aunque los congresos legislativos no avancen, por ejemplo, con la velocidad indicada, en encontrar las formas de pensar cómo que puedan conservarse los bosques. En Costa Rica, el principio indubio pro natura, por ejemplo, se ha utilizado en la jurisprudencia para detener proyectos, por ejemplo, un proyecto minero, el proyecto de Cruzitas, porque la Suprema Corte de Costa Rica interpretó que si bien podía permitirse ese proyecto minero, había una interpretación más benéfica que podía proteger más a la naturaleza, que era aplicar la legislación ambiental sobre la legislación económica. En Brasil, bueno, hay muchísimos ejemplos, no me atrevo a hablar de eso con el ministro Benjamin aquí, que es el más experto, pero en Brasil el principio indubio pro natura se ha utilizado para interpretar la normativa ambiental del sentido que más favorezca a la naturaleza, para equilibrar a las partes en el proceso, invirtiendo las cargas de la prueba, etcétera, para lograr una apreciación sistemática y no aislada de las normas, para describir las normas de forma minuciosa en aspectos temporales y encontrar la que más beneficie la protección de la naturaleza en el caso concreto. Y en México también, por ejemplo, el principio indubio pro natura se ha utilizado por la Suprema Corte para proteger a los bosques a partir del concepto de sus servicios ambientales. Y todas las instituciones del proceso se han reinterpretado a partir de los servicios ambientales de los bosques. Tiene derecho a interponer una acción judicial para defender un bosque cualquier comunidad, persona, organización gubernamental que se beneficie de sus servicios ambientales. Las medidas de restauración y de reparación de daños son la restauración de los servicios forestales de los bosques. En fin, no tengo más tiempo, solo espero poder dejar aquí esta idea de lo emocionante que está pasando en la jurisprudencia ambiental en la región, como una nueva forma de pensar el derecho ambiental para lograr resultados empíricos que se están traduciendo caso por caso en un nuevo corpus de derecho ambiental con efectos empíricos y de acceso a la justicia que creo que van a hacer la diferencia necesaria de la que hablaba el ministro Benjamin. Muchas gracias por su tiempo.
Gracias, doctora Alejandra Salinas, por su intervención importante, simpática y positiva. Muchísimas gracias. I'll give the floor now to Dr. Kenneth Angu.
Yeah, thank you very much, and thanks to everybody for participating. And also, I want to use this opportunity to thank the organizers. Also, that's the Prince Albert Foundation. So, and of course, IUCN, World Commission on Environmental Law. So, yes, actually, you know, this topic is very interesting in the sense that, you know, without law, there is disorder. So actually, especially here in the Congo Basin, it's we do understand that we have lots of people, various stakeholders that you know are managing, you know, that are really interested in forest management. Why are they interested in forest management? Mainly because, as we do understand, the forest in itself, it helps, it supports livelihoods to about 60 million people, and also even neighboring towns, those towns that are not in are not in forest areas, they always desert, you know, they have their food and everything from this forests that are just near them. Then also we do understand that you know, without the forest, most people, they have something, it becomes very difficult for them. Why am I saying this? I'm saying this just to show that we have a multitude of stakeholders with different interests. So that becomes very chaotic if we don't come out with something concrete, like a law, you know, to regulate the use of these resources, especially like the management and use of these resources. So that's why we have, for example, in Central Africa, you know, the Congo Basin, most of the countries, all of the countries, not most, excuse me, all of the countries, they have their laws in place, that's the forestry laws in place. That shows it's important, and that really regulates how people, the various stakeholders within that country actually manage their forests. Because if these laws were not there, then we wouldn't have really been talking of the Congo Basin forest as it is now, because it would have been degraded. I think the forest loss would have really been moving in geometric rate. And of course, you have, with the consequences that we have issues like poverty, soil erosion. When we talk of poverty, it comes also with social unrest, with conflict. There would have been a lack of water, food. There will be food insecurity. There will be migration, because people they will not want to be where they cannot meet their livelihoods. You know. Then the other issue also is, we have mentioned now about climate change. Then there will be also break in the sociocultural order in that sense because of all of this. So now these laws are there, we have line ministries actually that are there to support the implementation of these laws. But there's been a debate over the years, over the decades even, in Central Africa, because most of these laws actually are obsolete. Actually, when I talk of obsolete, because most of the laws were developed, for example, in the 1990s and 2000s, actually, most of the countries at that period. And the countries themselves know that. And they are taking steps now actually to upgrade the laws, you know. So, but the implication here actually is that some of the key issues of the day are not really taken care of by the law, although we have some other mechanisms that the countries have set up in place to make sure that these emerging themes, for example, are taken into consideration. For example, if you do understand that when these laws were developed, for example, in the 1990s, we were not really talking about the climate change as we were talking about. We didn't have the various COP, UNFCCCs and all the like. So, but the laws are being ameliorated. But now, when we talk about to update these laws, there are certain things that we need to take into consideration. My previous speakers, they have mentioned issues concerning participatory dialogue, you know, so that at this time, most countries, they're now realizing that it shouldn't be like this type of command and control type of enforcement, because it's shown that it hasn't worked. There needs to be some the law that, as Benjamin was saying, of recent, you know, laws in itself, they don't really work, except we tie them up with some sociocultural aspect within them, and that's why most often we talk of legal and also legitimacy. So within this essence, so the update of these laws are very important. As I said, some of the countries are already going forth with that. Others have already done and validated. For example, like the Congo Brazzaville their laws are being updated. Cameroon is updating its laws. So that is something that we need to take into consideration. Then the other aspect that we want to say, which is very important for us, is the implementation hurdles. these laws, they are there. We do understand that they are very important, but we have a lot of implementation hurdles. Implementation hurdles in terms of mainly because of the following reasons. One, at times people are very ignorant about the law. They're ignorant about the law, so they don't even understand how to do that. But we do understand in the various countries that ignorance of the law is will not make you, will not make the system not to punish you, because so that is it. Then the second issue also is at times there is lack of funds to implement some of these laws and everything. So just to take some of that, the issue here is that if anything is being now for those various countries, those who are currently developing their laws now, it's very important because they are now discussing with various stakeholders and capitalizing on the errors of the past to make sure that these emerging teams are not only integrated, but that the socio-cultural components of the various countries are taken care of, because most of these laws are being implemented, are being elaborated and implemented as per certain socio-cultural realities. Most of you have mentioned the issues about indigenous and local population. We need to, how are they going to use these resources? How are they going to manage it? Who are those coming into those communities to make sure that the communities manage themselves? How do they even manage themselves? Even if they have certain, they can manage their forests, how do they share the benefits, that accrue from these resources? Because those are some of the issues that create conflict. So that is also some of the issues that any issue that is coming up, new environmental law or anything that is coming up should take into consideration this aspect to make sure that the laws are taken care of, and they are also compiled and also disseminated to the various stakeholders. Another issue also concerning the law that is very important, that creates some of this implementation hurdles, is the differences between, I would say, the penal code and the forestry law. Most of the time, those some of the magistrates, for example, although they have been trained, they master the penal law very well. But at one point, just like in other laws, in other technical codes, like like the forestry code, some of them, experience have shown that they don't really understand the the type of sanctions to give to what particular I want to say what particular errors that people do on the field, So most of the time, it's very important that even, like, for example, in most of this training schools, some of this technical codes, not only the forestry code, you also have other technical issues like wildlife code, and also they should be taught also within this structure, so that any punishment that will be given to any party or any judgment should be appropriate, should be equivalent to the crime that had been committed. So these are some of the issues that we want. Then one key issue that, and I think Benjamin mentioned this from the beginning, is that yes, most countries have been focusing on the internal, that national laws, but finally it's not enough, because to manage the Congo Basin forest, they need to, the countries need to come, they need to manage them. You have transboundary protected areas, for example, the various animals, wildlife, they don't have frontiers and everything. So that has become a real issue, because at one point, one country is so, it's very stringent in managing this laws, but in the other country, nothing is being done. There is poaching on the other side. So now the 2 countries, the 3 countries, the 4 countries, they need to come in. And that's where COMIFAC comes in. COMIFAC has been doing a great job, together with the various countries, to make sure that there is this harmonization of these laws, at least at the regional level, to make sure that, in some ways they are being harmonized. And that's why we have a lot of, most of the organizations that are inviting, for example, these magistrates and law enforcement officers. I'm talking not only magistrate, but also law enforcement officers like the police, the gendarmes, you know, and the lawyers also to, you know, to train them to understand these laws and so that by implementing them, by even during court sessions, they should really understand what is going on, the gravity of what particular crimes and how it can be judged and how, you know, some of these issues. So that is something that is also, it's very important for us. So in the nutshell, yeah, as the time is almost going. So to conclude, the way forward actually is to make sure that we capitalize on the ongoing process, that is the ongoing process in the countries where they are updating their laws, to make sure that, you know, we work with them, and all of the government actually, they do understand and they want a participatory type of something. So that's why it's an opportunity for all of us to make sure that we integrate some of those aspects that were not in the laws that were adopted long ago to be included, so that because once we do that, we need to wait again for the next, I want to say the next 20 to 25 years before that happens. So thank you very much for your attention.
Thank you very much, Dr. Kenneth. Very interesting and good points raised by you. The experts here will have a lot to think of with your contribution. Many, many thanks. Professor Eeshan, I'll give the floor to you, please.
Thank you, Ambassador Lima. I'll also request the organizers to let me know if I exceed my time limit. I have a timer on with me, but just in case. Again, thank you so much, Justice Benjamin, Professor Christina Voigt. World Commission on Environmental Law continues to do incredible work and get conversations front and center of everyone's screens in this day and age. What I plan to do and how I plan to maximize and utilize the next 10 minutes would be in the following structure. So I'd like to start with a question for everyone to think over as I continue my talk over the next 10 minutes. I would then get into some current facts, especially focused on Asia and South Asian forests. I will then get into some of the legal developments in this jurisdiction and end with some of the things that we need to think about, both in terms of legal arguments, but also in terms of ontological and epistemological moral arguments. So the question that I want everyone to think about over the next 10 minutes or so, well, 9, as I realize the time is running by, is a question that some of us might have heard of. And if we haven't, maybe we could give it a thought and maybe not Google it right away because you'll find the answer. But the question is, how much land does a man need? Exactly in those many terms. So how much land does a man need? And there's a reason why I'm using a specific set of words in that question. As I said, we'll move into some of the numbers now. And because I'm trying to focus on South Asia, these numbers relate to South Asia and the forests in South Asia. So we might know that South Asia is home to 2 billion people. This is common knowledge. Well, now it's a little more than 2 billion people, but there and thereabouts. South Asia is also home to 15% of the world's tropical forest and includes at least 4 of the 24 globally important biodiversity hotspots. It is also one of the major regions which is being deforested at unprecedented rate. Between the year 1900 and 2010, 1990 and 2010, the Southeast Asia registered an average net loss of 1.6 million hectares of forest per year. Let me repeat that again, 1.6 million hectares of forest per year. Now, at this rate, it is feared that over 40% of the region's biodiversity may vanish by the end of this century. And we're talking about a biodiversity hotspot region of our world. So in this panorama of facts related to countries and forests and continents. I want to discuss some of the legal developments that have transpired over the course of the last few decades in Asia and South Asia. A majority of countries, as Professor Angu and Justice Benjamin and Professor Voigt discussed, a majority of countries have extensive environmental law frameworks and forest law frameworks in most South Asian countries as well. In most of the countries now, you have departmental authorities or forest authorities that have their work cut out. In fact, so much so that some might say that there is now an abundance of forest law, so much so that there is almost an overlap of authorities and laws that might deal with the same issues in the long run, which is something that needs to be addressed. A lot of the South Asian countries also have dedicated judiciaries, active judiciaries. Activists might not be the right term. And a lot of the countries in South Asia have also opened the gates of access to citizenry. And what I mean by that is standing rules, whether it be Nepal or India or Pakistan, standing rules have been relaxed for any person aggrieved who might not directly be related to issues that he or she is facing in terms of forests. So this is the structure that we're dealing with in Asia, in most of Asia at least. It is also an excellent thing to note that in a recent study, it was found that more than 3/4 of the world's national constitutions, about 149 out of 193, include explicit references to environment or forest rights and responsibilities. Recently, I came across Article 30 of the Nepali Constitution, which specifically grants you a fundamental right to clean environment, which is something that we should take note of and applaud whenever we get the chance. 36 countries in Asia on an average or generally have a constitutionally recognized right to clean environment or clean forest. Another facet of legal developments has been the constitutional Supreme Courts in these countries have included the right to clean and decent environment as a part of the fundamental right. In last count, there were about 8 countries that have explicitly done this in South Asia. Now, this paints a picture which might tell you that, all right, so this is all going well and we're on the right track. But that's where we need to think about the problems that we all are aware of and we have observed and have been alluded to before I spoke. There is a big void generally around the globe in terms of forests, and we'll come to as to why this void might exist. But there is a gap relating to what is called legally, or in legal academia, the implementation gap, which basically means that there are extensive laws, in some cases dedicated environmental courts, dedicated judiciaries who are active, access to citizenry now. And despite all of this, forest protection has not been the kind that one would expect. And this can be for a variety of reasons, especially in Asia. This could be because of a lack of adequate human and financial resources for people to have enough resources to actually approach their courts or elected governments and such. It could be, as I mentioned, because of gap or an overlap in judicial or institutional authority. So who do I go to? Do I go to the forest officer? Do I go to the local court? Do I go to the constitutional or the superior court? Do I go to my elected representative? And overlaps in legal frameworks can also create complications. So how do you address that? There could, and we all might agree to this, there could also be a big chasm between understanding of issues and information of issues. is forest education going to the absolute grassroots in an ecocentric worldview of forests generally? So lack of awareness and familiarity with environmental laws and policies, so legal education, and lack of awareness and familiarity with forest as a resource and as something that is absolutely necessary for us to survive as a species. Finally, we might observe that in some cases, there might be a lack of political will, a lack of administrative will, and in the worst of those cases, corruption that might hold all of these wonderful aspects of forest conservation back and lead to an implementation gap. Now, with that being said, access to sue for forest issues has been generally expanded, and judgments by courts have been passed more frequently in recent times for protection of land use change as well. And that is something that we need to concentrate on, because indigenous people's rights have to go hand in hand with protection of land use, preventing change of land use from forest to otherwise. Now, I know I'm running out of time, so I'll quickly just mention the pointers that I think need to be addressed as we go forward through such conversations and continuing conversations. First is a moral argument that I wanted to bring up. Land and forest, historically, traditionally, for the last 10,000 or so years, have not just been resources, as much as we try to think that we've been absolutely anthropocentric when it comes to forests. Lands and forests have been a part of identity. For a majority of the global population, those of us who do not stay in urban cities would tend to agree more with this. But there is a culture in India where you're named after your village. A part of your name is your village, and that identity derives from the ecosystem, from the forest that you're a part of. So identity is intricately related to forest, and that is something that legal scholars should concentrate on going forward. And the rest of them, the rest of the issues that I needed to just mention in passing were ontological issues. Specifically, ontologically speaking, lawyers and judges, with due respect, need to develop an expertise in forest. It is the need of the hour internationally, globally, to be experts in forests and to be able to disassociate specific criminal and civil issues with environmental and forest issues. The second was, as I mentioned, there's a need for forest education at the grassroots level to turn an anthropocentric view of the world to an ecocentric view of the world. And finally, some of the epistemological issues that I wanted to mention. One, Christina raised an excellent point on how leakage is going to be a bigger and larger issue as we go forward. So if you protect one piece of land, the industry will go to another piece of land. And that's why, as Justice Benjamin was mentioning, it needs to be an international effort. It cannot be a domestically constrained effort. There has to be movement internationally. Dr. Angu talked about migration, again, a connected issue that makes this an even more epistemologically challenging problem. And finally, forest administrators, indigenous people, forest laws, judges, lawyers need to be brought to the same plane in a more participatory approach, something that we're following in now, Nepal, India, and some of the other countries of the world. So that was my time. I leave you with the question. If anyone is curious about the question that I started with, I'm happy to address it later, but that's my time. Thank you so much, Ambassador Lima, for the opportunity.
Thank you very much, Professor Eeshan. Thanks for the question. I'm still thinking about it, and I hope everybody is doing the same. Very important issues raised. Thank you for your contribution to our dialogue today. Now I'll give the floor to Professor Andrew Heinrich. You have the floor, Professor.
Thank you very much, Ambassador, and thank you everybody for coming today. Thank you so much to the Prince Albert II Foundation of Monaco, and especially to Prun Zanino, whose magic made everything happen today. Thank you also to Roberto Colli for for his organizational efforts, and to the amazing panelists who I have had the privilege of following today, who've brought up such incredible points. Thank you also to everyone in the audience. I know there's so many amazing advocates and scholars and leaders amongst you here today who bring such great work to the table for your communities and for the areas you study, including some great friends of mine, Dan Wildcat and Leslie Iacocca back in the United States, who advocate on behalf of Indigenous communities and their scholarly communities, nation and worldwide. The previous intervention mentioned the idea of the implementation gap, and that's where we're going to pick up with my conversation. I'd love us to investigate implementation, meaning access to justice for particularly Indigenous communities, and we'll do this in 4 parts. First, we'll ask the question, why Indigenous land rights as a central element to this discussion? Second, we'll go into some matters of litigation. Third, we'll look at a case study, one with which many of you will be familiar, from Ecuador. And then finally, I'll have some brief comments on international arbitration as an area for improvement in this space as well. So first, why are we discussing Indigenous land rights when it comes to forest conservation? Indeed, the proposal is that Indigenous land rights are a mechanism for forest conservation. And as was very much discussed in the first webinar, that it's a tool by which to achieve forest conservation. I think many of us know, either anecdotally or broadly speaking, about the conservation benefits that a forest enjoys when Indigenous land rights are conferred back to an Indigenous population. But I wanted to draw everyone's attention to a publication from a research team at the University of Colorado at Boulder that was published earlier this year. The data is staggering. It says that gaining land tenure, and I quote, was associated with an average of 0.68% percentage point annual decrease in net deforestation. So that is over 0.5% of decrease in net forestation per year from land tenure being granted back to Indigenous communities. If you multiply that over a number of years, obviously the results are staggering. And it shows that, of course, in addition to the brilliant scientific work that's being done by those in the natural sciences, that sometimes the obvious answer is the right answer. And handing stewardship back to Indigenous communities might be the only intervention needed, full stop. There's a growing literature in this space. The study out of the University of Colorado was one of the first to quantify on a large N study these impacts, and I hope that there's more in that vein, because I think it will really justify the continued efforts that are being made in this space. Crucially, it was only legally codified full land tenure that led to the significant deforestation. Qualified land tenure did not have any impact at all. It was no different than untenured land. So it really comes down to the Indigenous land rights being, fully legally codified and tenured rights, that land tenure that lead us to the result. So let's talk a little bit about access to justice, the implementation gap. As has been said by all of my colleagues, national governments have been increasingly granting land rights to Indigenous communities. There's been increasing incredible work on forest conservation in legal frameworks. But we know that these rights are not upheld and these rights are violated, and that one of the ways that access to justice is ascertained is through the courts. And so I'll start with litigation as a tool to uphold Indigenous land rights. And I wanted to just explain some of the elements of litigation that I think are most crucial for us to discuss. There are 4. The first is I'd like to start with causes of action and standing. This is very much related and at the heart of the issues that were mentioned in past interventions. A cause of action is what you're suing about. How is it what is it that's been taken from you? And there are really two genres of causes of action at play here. One is the violation of land tenure, and the other is the question of either violation of environmental rights or of access or of health rights. And those are very commonly used in Indigenous communities in spaces where I work in particular. The challenge that the second one creates, even though it's still statistically more common, in other words, more indigenous communities are still bringing causes of action based on health damages than they are based on land tenure damages when you look at a large N study, meaning a large data set, is the issue, the issue of standing comes up. In other words, why do I, the indigenous person who's been harmed or whose health is negatively affected, get to sue the other party? There's questions of foreseeability, meaning that can the company conducting the action, let's say off of tenured land at the moment, really foresee that this individual might be harmed by it? Can you prove proximate cause, that that's what's causing the health issue? That goes somewhat into the issues of the substance of the case, but it comes up in standing as well. And so what I think we learned from thinking about causes of action and standing is that bringing more claims based on land tenure and strengthening land tenure causes of action are really important. And to those of you who work in the legislative space, I really want you to think about this carefully. I have a great colleague, I formerly worked in US government, and I had a great colleague who always said, whenever you create a right, think of how someone's going to sue for it as you write the law. And I encourage you to think about that question coming out of this causes of action conversation. How is it that especially land tenure rights can be claims can be brought more thoroughly, and the tenure rights themselves can be granted more comprehensively, so that those claims can be brought more than the health-based causes of action, which can be harder to get standing on and harder to prove. Second, I want to make a brief practical point on evidence collection, testimony, and just running the case from an attorney's perspective. There are a lot of practical challenges that come up with these cases. That's one of many reasons why they often take a decade or more. And obviously, time is of the essence for so many reasons, of course, not least of which are conservation reasons, but from my perspective as well, true access to justice for those who have been harmed and those who are often ill as a result of what has happened. So I think that thinking about how to overcome these practical challenges, how do we think about cultural barriers that might exist in collecting evidence? Conducting transnational litigation is never easy, much less when the plaintiff might have geographical challenges to coming together, for example. So I encourage all of these to be thought of. And if you're in a role where you might have a central function in facilitating litigation, or arbitration, I encourage you to think about these practical challenges as a first step. That's where truth-telling might come in. This is where evidence collection can be done pre-litigation, and hopefully somewhat smooth the way. The third comment I want to raise is on that of damages calculations. I am not a damages expert, but by any stretch, but I will make some brief comments on the difficulty of calculating damages. I think everyone knows that damages in these sorts of cases can be very, very difficult to calculate accurately, certainly on an individual scale, but if you're in a class action or a mass torts claim, or if you're under some sort of community theory of personal jurisdiction or of cause of action, you will find that it is extremely difficult to calculate damages, perhaps impossible. Punitive damages can often be arbitrary at that. So the damages that are not to compensate the victim, but to say on top of that, we'd like to punish the defendant. Now, these questions might be near impossible to answer in the abstract. I'm sure a damages expert, if one were to join this panel, could give us much more insight than I could. But we come up with a problem, and the problem is enforcement. And the damages calculations and the enforcement question are intimately linked. It's not the entirety of the enforcement question, but it's linked. And it's linked because, as many of you may know, when enforcement measures start to happen, one of the things that a defendant will lean on is arbitrary damage calculations. That'll particularly happen in investment arbitration cases where they'll say, we definitely don't have most favored nation status. They will say, we definitely are not we're not getting fair and equitable treatment because look at how we're being punished excessively relative to how a domestic company would be damaged. Among many other issues in enforcement that I would love to get into if I had another minute or two. Commenting briefly on arbitration, just noting that my time is running low. There are so many opportunities for arbitration, international arbitration, to play a greater role in this space. There are more and more human rights and environmental conditionalities being put into bilateral investment treaties and multilateral investment treaties. And that's a great opportunity for those of us who care about using arbitration as a tool towards that end, and using the negotiation of those treaties, if you're in governments, to achieve greater protections for your indigenous communities and therefore the forests in which they live. Hopefully, we can see greater growth in the arbitration space such that the things that I've mentioned, the ways in which arbitration has been used to block enforcement of litigation with favorable outcomes thus far, are overcome, and that investor-backed expectations is no longer a shield behind which to stand if you are a multinational corporation. I was going to run through an example, but I'll leave it to pepper it through any responses I may have to the Q&A, because I wish to observe the time limit. I just want to conclude by saying that it is essential to think about how these rights are enforced and upheld, and how violators of these rights are held to account, if we are to see meaningful progress in conservation efforts and the parallel needs, maybe even the antecedent need of achieving indigenous land tenure rights in its fullest sense. And more work is needed to facilitate access to justice for these indigenous communities whose rights are violated. We're seeing growth in the space, but it will, even if enforcement never ends up going as we'd hope, we're seeing progress in this space, and more progress in enforcement, and indeed a bringing of these claims to begin with, is essential to achieve our goals in deforestation. So thank you very much for your attention, and I look forward to our forthcoming conversation in the Q&A.
Thank you, Professor Andrew. Another very important contribution. Now, as according to the program, we have closing by Director Eeshan. Is it? So he has the floor.
Thank you very much, Excellency. Thank you, Ambassador. Thank you to all the presenters for the expert presentations. Thank you as well, of course, to our co-organizers, La Fondation Prince Albert II de Monaco. Much appreciated. It certainly was a very informative webinar so far, and I'm excited about the session that is still to come in terms of exchanges. Of course, it was not a surprise to many, but we learned about the importance of forest. We covered issues of synergies, trade-offs, and leakages. We learned more also about the central role that law can play and plays in conservation, and the importance of careful law design and impactful and inclusive implementation. We saw as well how the very nature of the participants to the webinar showcased how forests are a common motive of preoccupation all over the world. We also were challenged because while it may seem obvious to protecting forests may be easier than protecting wildlife or climate, it can be misleading. We saw the centrality of people that depend on the integrity of the forest systems. We saw as well that forests cannot be seen solely as a local legal issue, and that is problematic for judges. We saw how there is a gap, that there is no international legal regime for the protection of forests, and we saw how laws by themselves cannot protect forests, that we need laws in combination with strong institutional frameworks. We also discovered concrete examples of how we can make a difference in conserving forests, including through courts. We saw how it is fascinating to see the evolution of jurisprudence and how it is enabling new interpretation when it comes to environmental law. We saw again the important role of forests in support of livelihoods, including in Central and West Africa, the important role of law in regulating among different interests, and how we need to update laws that may be considered obsolete. We saw that it was important to connect social, cultural components to environmental law and to capitalize on ongoing processes and not to invent the wheel. We were challenged with a question: how much land does a man or woman need? I'm very excited to discuss further this conversation and this question in the upcoming session. We saw and were challenged by the scale of forest degradation and the interconnections when it comes to that forest degradation with the triple planetary crisis. We were presented with a brief overview of the current state of play of environmental law frameworks, institutional build-up in terms of development and challenges, including when it comes to the recognition of a right to a clean, healthy, and sustainable environment. We saw how indigenous land rights are a central element for forest conservation. We also discussed access to justice, to litigation and case studies, to course of action and standing lengths, as well as challenges when it comes to calculating damages just now. And finally, we learned about the potential of international arbitration. Looking forward, we are very excited about the Forest and Communities Initiative. We learned about the approach, deliverables, and timeline of this important initiative that aims to be long-lasting and actively participate in the protection of forests and the biodiversity to the actions of the people who live within and around them. The IUCN Work Commission on Environmental Law is keen to build on today's collaboration with the Fondation Prince Albert II de Monaco for impactful outcomes. When it comes to the IUCN Work Commission on Environmental Law, first and foremost, there is the Model Forest Act Task Force that is chaired by Justice Antonio. Secondly, still within IUCN, there are several other task forces and specialist groups where forests are of direct relevance. The Global Judicial Institute on the Environment Task Force, Rights of Nature Task Force, Biodiversity Law, Climate Change Law, Early Career, Environmental Security and Conflict Law, Ethics Specialist Group, Soils and Sustainable Agriculture, and Water and Wetlands Law are among those that came to mind as I was listening to the very impactful presentations that we all enjoyed. Finally, wearing the hat of the Hassan II International Center for Environmental Training, the academic arm of the Mohammed VI Foundation for Environmental Protection, chaired by Her Royal Highness Princess Al Hasna, we are very excited to further engage on capacity building activities and happy to also be currently working on deepening our collaboration with the Fondation Prince Albert II de Monaco, particularly on ocean issues. I would like to thank the co-organizers again, all the speakers, participants, technical support, and translators. Apologize to the translators as they must be having a very hard time right now to translate what I'm saying. I'm sorry, I tend to speak very fast. And again, I wish you all a most productive and informative excellent session. Thank you very much.
Thank you very much, Ayman, for that great closing on all of the topics. So I think we'll be able to open the floor. I think I will go through the questions that have gone up already on the chat, if that's okay. And then I'm going to ask people if they have more questions, either type it on the chat or just raise your hand like we did the other day, and then we'll give the floor to everyone, to each person once at a time, if that's okay. Right, I'll take the silence as a yes. Superb. So the first question that came from Dil Raj Kanal a bit earlier, I'm going to read it out, and Raj, if you think that I haven't made justice reading in, feel free to step in. So the legal recognition of collective and community tenure rights of IPRCs is instrumental for the sustainable management of forests. However, in many countries, human rights-based approach are yet to be mainstreamed in the national forest legislation. Domestic forest legislation are being influenced by the carbon market approaches, which will undermine the community collective rights of IPRCs in developing countries. In this situation, how can we secure the collective tenure rights of IPLCs over their community customary forest? In the panel, who would like to start answering this question? I can see, Antonio, that you're off mute.
I'm on mute.
Fabulous. Go.
It's dealt in other pieces of the legal system, either in the Constitution or in the legislation that protects indigenous people. What we can do in the forest legislation is to make a reference to the existing land tenure regime. But it's very difficult to bring this whole discussion directly into the forest law, because it doesn't apply just to forests. It applies to land more broadly. It applies to water. It applies to wildlife. It applies to the carbon market. So those are very complex issues in themselves, and I doubt that at least in the Model Forest Act that we will have that it's feasible to bring this discussion directly into the framework. But I know, and it's a little from the global different legal systems, the land issue regime is either in the Constitution or in the Civil Code or in agrarian reform law, etc.
Thank you, and thank you, Antonio. Christina, you raised your hand, I think, to answer after Antonio, right?
Yes, I can switch on my camera, but I can still speak. I come in with a slightly different hat. I've worked for a very long time on REDD+ and carbon markets and indigenous people's rights protection. And I just wanted to agree with what Justin Benjamin just said, that the protection of indigenous people's rights, that's perhaps an issue for forest acts, for human rights acts, but how it relates to carbon market is something that needs to be regulated in the international and national regulation for carbon markets. And here, I think it is very important to say that there doesn't have to be a contradiction between indigenous and local communities' interests in carbon markets, but that only happens if carbon markets are very carefully regulated and have very strong safeguards that do protect indigenous people's knowledge and rights. And we had first attempts for that under REDD+, and for the current development of carbon markets and the Paris Agreement, that's still under negotiation. But it's a very, very important development, and that's something that needs to be very closely watched, as well as how it's then also implemented in domestic legal systems. But as I said, it is something that many countries are currently developing, and it is very important to keep a very close eye on what's happening in this area. Thank you so much, Bruno.
Thank you, Christina, especially as I know you're a bit traveling as well. So thank you so much for coming back to us. Right. I think the next question is, so a lot of people have raised your hand. We have one person on the floor verbally, and then there's two other questions by chat, and then I'll come to the other people on the floor. So Martha Nunez, do you want to unmute yourself, present yourself? Where do you work? Where are you located? And then ask your question.
Muchísimas gracias. Buenos días a todas y todos. Buenas tardes, buenas noches. Depende. Gracias por el panel. Excelentes las presentaciones y muy difícil en realidad de tomar todos los puntos planteados. Excelente también el resumen hecho por el colega. Hay varios puntos que quisiera yo mencionar, pero uno de ellos que sería muy importante que sean tratados en futuros paneles, y es el hecho de que se ha hablado mucho de la tenencia de la tierra y los instrumentos legales para asegurar esa tenencia de la tierra, especialmente de los pueblos indígenas. Y creo que hay un factor que se debe considerar, que no se ha tomado en cuenta aquí, y es las regulaciones que tienen a su interior los pueblos indígenas, que, por ejemplo, han sido planteadas ya en otros foros internacionales o en otros foros de similares características a este, y es la exclusión que se hace con respecto a la tenencia de la tierra para las mujeres. Y eso creo que debe ser considerado con gran atención. Un segundo punto que quería tratar es el tema de uno de los panelistas lo mencionó, y es la falta de compromiso político para el cumplimiento de la legislación que existe en relación con los bosques. Y no solamente es la falta de compromiso político se expresa en eso, sino en cuestiones tan sencillas como el hecho de que espacios internacionales como la Convención de Biodiversidad o Cambio Climático estén atestados de participantes y de gobiernos y se hagan declaraciones casi de carácter vinculante, casi ninguna es vinculante, pero al menos se hacen declaraciones como la que tuvimos en Glasgow, lo que se acaba de ratificar en Egipto, etcétera. Sin embargo, un espacio que se inició precisamente por la falta de un instrumento legal vinculante sobre bosques, que es el panel de bosques y ahora el llamado foro de bosques, no tiene la misma participación. Ahora mismo se va a realizar la sesión 18 y ni siquiera se va a poder hacer una reunión híbrida. Y no va a haber muchos, muchos gobiernos y sectores de la sociedad civil no van a participar. Otro punto que quisiera también mencionar es que muchas veces hemos hablado de que las causas de la deforestación están fuera de los bosques. Y es precisamente lo que se ha mencionado aquí, que está relacionado con el tema de la legislación y de las políticas que se contradicen entre ellas y la legislación que se contradice entre ellas. En Ecuador, por ejemplo, tenemos en nuestra constitución, es una de las pocas constituciones del mundo que reconoce los derechos de la naturaleza. Eso es algo muy importante. Tenemos también, en cambio, a la par, cierto tipo de regulaciones en las que el Estado es el garante, el protector de los recursos naturales que están en el subsuelo. Y eso contradice con los derechos de los pueblos indígenas que se encuentran en esos territorios, en cuyos subsuelos se encuentra petróleo, por ejemplo. Y es difícil poder tener políticas que puedan garantizar los derechos de esos pueblos indígenas que están en territorios donde se encuentran recursos naturales en sus tierras. Eso está pasando no solo con el petróleo, sino ahora también con la minería, sobre lo cual tenemos muchos problemas. Y en ese sentido, pues sería interesante que se pueda analizar todas esas contradicciones que existen. Se ha dicho que las leyes de bosques, dijo el colega de Gabón, me parece, o del Congo, perdón, que son leyes que ya están fuera de la actualidad. No solo pasa eso, sino que precisamente se contradicen con el resto de la legislación. Creo que la colega de México habló sobre eso también, de este tipo de contradicciones, y que ahora hay un avance en el tema de la legislación y el uso de la indubio pro natura, pero creo que no es tan suficiente, digámoslo así, para poder enfrentar todos los problemas que tenemos en relación con el manejo de los bosques, la conservación de los bosques y de la biodiversidad en general, y las leyes ambientales, que obviamente están por debajo de leyes de carácter económico. Gracias y disculpen haberme tomado tanto la palabra.
Thank you, Martha. Right, I think there are some other people on the floor who would like to raise their question. Could you please ask your question and keep it short? I'm really sorry, but we're really short of time, and I want to make sure that we have all of the participants asking their questions to the panelists. So we'll go to Brian Rohan, please.
Great. Thanks very, very much. And really a huge thanks to all of the presenters for some very, very interesting points. And I'm with Client Earth. I'm based in London, where we run a series of programs, including partnerships with local communities in tropical forest countries, trying to use the law on a very grassroots local level, but running into the frustration that community by community, state by state work runs into a wide range of the political commitment and implementation issues that the panelists mentioned. So I wanted to get the panelists' perspective on the global biodiversity framework, which we've been looking at very closely. You know, it just recently enacted in Montreal in December, and containing some very, sort of strong statements of protections for Indigenous peoples' rights, and sort of making those statements and protections available on a global basis. And I just wanted to get the panelists' perspective on the potential utility of the global biodiversity framework, perhaps in comparison with the Model Forest Act or other instruments as well, in terms of compelling greater state-by-state respect for Indigenous peoples' rights and offering some sort of comparative analysis because of the large framework of the Convention on Biodiversity. So any thoughts from the panelists on that would be very interesting and much appreciated. Thanks very much.
So in our panel, who would like to answer on this one? Andrew, you have your hand up, so you go first.
Great, and thank you for the great question, Brian. So I think you're right that Montreal gives us many reasons to be hopeful. I think particularly cause of action, if you use the framework of kind of challenges that I presented, I think cause of action is the one that's most meaningfully addressed in the space as is standing. So I think kind of part one of those 4 questions, I think the framework will help us with the most, provided, of course, there's national implementation. Obviously, when you have an international framework, you have the same implementation questions that we have on the domestic level, just scaled up to how states will implement an international framework and how communities will access justice just the same. But I think that that's where where the greatest need is addressed. If there's something that's unaddressed, if I'm allowed to go in that direction as well, I continue to focus on the latter 2 points, damage calculation and enforcement. I think those are 2 areas where damages will be more complicated to address on an international level, but there are other frameworks from other areas of law where we've decided to simplify damage calculations at risk of making them overly simplistic and maybe under-deliver in some cases and over-deliver in others, just for sake of simplicity. And then the other, I think, missed opportunity is some of the enforcement questions, particularly in how how everything that's coming out of Montreal will interact with, say, the international arbitration frameworks and investment protections, to ensure, like I said, and I said it somewhat facetiously, but that investment protections aren't a shield you can hide behind when it comes to enforcement as a multinational corporation. So thanks again for the great question.
Super. Thank you so much, Andrew. Unless there's anything else to be said on that question for this question. So we have 2 questions in Spanish, and
can I say something about this question?
Of course. Go ahead.
And in connection with the previous question from our colleague from Ecuador, the good news is that the biodiversity international legal regime is expanding and is touching on issues that were unthinkable just 10 years ago. The bad news is that at the end of the day, what really matters is national legislation. So, Brian, good luck if you go to court anywhere in the world with a very strong paragraph, no doubt about it, from either the Biodiversity Corp or even the Climate Change Corp. So this transition is one that has to be made, and it takes time. The problem is that there is no time for action in respect to deforestation, especially deforestation that affects directly Indigenous people. And I mentioned directly just because I want to connect with the previous question. A lot of the damage to Indigenous recognized territory is done not inside the territory, but outside of the territory. especially in respect to water, but can also be deforestation in the surrounding area affecting the climate in the forest that remains in the recognized indigenous land. So it's complicated, but the good, I end with good news too, is that we have the means at least to mitigate the damage that is being done. My final comment, if I may, Prune, has to do with the 2 points that Andrew mentioned. One is the issue of standing, and the US situation with cause of actions and all, you know, the Supreme Court jurisprudence and the different 50 countries, not even state legal regimes for civil procedure. It's not exactly what we have in other parts of the world. In other parts of the world, we have either countries that fully recognize standing to sue. That's the good news. But the bad news is that we have something much worse than, or complicated than what you have in the United States, in which judicial review is blocked, not just for deforestation claims, but for the protection of indigenous peoples as well. And that's something that we have to be mindful to that. I had another comment, but I leave for my final on arbitration and how we can bring arbitration in this debate.
Yeah, can I add something also?
Go ahead.
Yeah, thank you. Yes, actually, I just want to add to what Benjamin was saying, but go at the macro level. You know, at one point, most of this international framework, they are very important. But as you agree with me, even although Brian is happy that at least this framework came out with something positive for indigenous and local population, some other people there were still not yet happy with it, especially because they mentioned that they were going in for something that was even more than that. For example, they wanted indigenous population, for example, their territories to be regarded as a conserved area, for example. So some of these issues. So at the end of the day, what is important with this international frameworks, you know, whether it concerns the biodiversity framework, it concerns the UNFCCC or what, by the end of the day, we still continue to be doing the good job that we're doing on the field, making sure that at the micro level, we enlighten, you know, the decentralized and deconcentrated state officials to implement that law, because some of the issues are coming there even because down at the lower level, they don't even understand how to implement the laws. Some of them are still in command and control, not because they want, but because they didn't know. So we as partners, we still have a lot to do because the framework is something that guides us, which is really good for us. Thank you.
Thank you very much. Right, I think we are going to be able to go to the next question for who is for Antonio. Alejandra, because of the fact that it's in Spanish, would you mind reading it out loud, please?
No, yeah, it's my pleasure. Just give me 1 sec to open the app. Hay 3 preguntas en español. Una dirigida para el ministro Benjamin. ¿Quiénes deberían ser los implementadores de las leyes de conservación y protección de los bosques y pueblos indígenas, si sabemos que los pueblos indígenas son históricamente excluidos de toda política pública en materia de conservación? Otra pregunta que es muy relacionada y me parece que podrían abordarse juntas para Dr. Eeshan. La mayoría de los pueblos indígenas tenemos una visión cosmocéntrica y animista. ¿Esto es lo mismo decir que ecocéntrico? Esas son las que veo, Prune.
Muchas gracias, Alejandra. Can I start with you, Antonio, with your answer? If you speak in English, then the translators will do the question for the translation for in Spanish.
Muchas gracias por la pregunta. The issue of standing, as Andrew, you mentioned, is one that's crucial, but it's crucial not just for access to the courts, it's also crucial for access to the administrative state. For example, to challenge in a hearing internally within the administration a permit for deforestation, for example. As I said, in many countries, the laws of standing have been relaxed, and relaxed not just for class action or for damage, but relaxed in all areas that, in theory, a case or an action can be challenged, be that challenged in court or within the administration itself. What is important, and we didn't touch this very much, although Andrew did mention damage, is about remedies. For those that are not from law, remedies are, what you are asking the court to do. And this is absolutely crucial in the protection of forest. One, we should not wait until damage is caused. In other words, we should prevent the damage to forest because we don't know what is there. Most of the tropical forest systems in the world are still unknown in terms of the number of species, even trees. We are discovering new species of trees every day. Second, the remedies, if damage occurs, the remedies should not be, the first one, financial, because we cannot put a market price on something that you don't know exactly how much it values. And if you want to do it, there are very complex natural resource damage techniques that will be unavailable, I would say, in most places of the world that hold tropical forest. So the first remedy is restoration. And then, in addition to restoration, financial damage. And in addition to financial damage, we, some countries, including my own, have this new technique that we call a collective moral damage. And this has been applied to indigenous land. One, the defendant has to restore. Second, the defendant has to pay compensation, and we take away all the profit that has been made by the deforestation. And third, there has to be moral or collective moral damage to the community itself. So we could go on, but that's for another seminar like this.
Alejandra, do you want to add anything?
Sí, muchas gracias. Quería solo añadir tres cosas. La primera, respecto a la pregunta sobre si hay una identidad entre las cosmovisiones indígenas y una postura ecocéntrica. Yo pienso, y con todo el respeto que tengo que usar, porque yo no soy una persona indígena, entonces no me corresponde a mí hablar sobre su cosmovisión, pero sí pienso que donde hay una identidad que cada vez se acerca más es en el reconocimiento de los derechos de la naturaleza dentro de los sistemas de justicia o en otro tipo de alternativas como el reconocimiento del valor intrínseco de la naturaleza, el valor de la naturaleza por sí misma, fuera de una visión utilitaria, donde se tengan que probar daños a la propiedad o daños económicos para que alguien tenga standing, por ejemplo, como lo mencionaba el ministro Benjamin, bajo esta visión cada vez más amplia para poder defender a la naturaleza. La Corte Interamericana de Derechos Humanos en una opinión consultiva muy importante, la opinión consultiva 23-2017, donde por primera vez abordó de forma extensa el derecho humano al medio ambiente sano, dejó muy clara que la protección del derecho humano al medio ambiente sano involucra tanto una dimensión individual como una colectiva, y tanto una dimensión antropocéntrica, donde, pues claro, estamos hablando de un derecho humano, se protege a las personas, pero también una dimensión ecocéntrica, donde todos los sistemas de justicia tienen que reconocer el valor intrínseco, el valor por sí mismo de la naturaleza y protegerla desde ahí. Y eso tiene muchas ramificaciones en el proceso. Por ejemplo, el standing, que tiene que garantizarse a cualquier persona que quiera defender a la naturaleza. En México la fórmula, por ejemplo, es si se beneficia de los servicios ambientales de un ecosistema. Y respecto a lo que decía el ministro Benjamin, por ejemplo, otro tipo de soluciones novedosas que en países como México, Argentina y Colombia se están instrumentando es que las cortes están nombrando comunidades indígenas, comunidades rurales, organizaciones no gubernamentales, científicos, como guardianes del cumplimiento de las sentencias. Es decir, si en una decisión judicial se ordena la restauración de un ecosistema, porque es la única forma de reparar la violación al derecho humano al medio ambiente sano, por ejemplo, entonces se ha nombrado en algunas decisiones de cortes de la región a personas, por ejemplo, afrocolombianas, en el caso del río Atrato, en el caso de México, a personas de una comunidad cercana a una laguna de manglar que se destrozó, para que sean quienes dan seguimiento al cumplimiento de la sentencia junto con instituciones científicas, y solo cuando la restauración ha ocurrido, las cortes liberan el remedy o el cumplimiento de la sentencia. Y yo creo que también, por último, respecto de la pregunta de la exclusión de los pueblos indígenas, es muy importante todo el tiempo traer a la mesa tratados internacionales, por ejemplo, como el convenio 169 de la Organización Internacional del Trabajo, que obligan a dar la garantía de los derechos de acceso a la participación, a la consulta previa, libre, informada y verdadera a las comunidades indígenas como un parámetro. Cualquier decisión que involucre territorios indígenas donde este requisito no ocurra, se invalida en los sistemas de justicia, porque no cumple el requisito principal de priorizar los intereses indígenas, que el mecanismo más frecuentemente utilizado es la consulta y la autodeterminación. Muchas gracias.
Muchas gracias, Alejandra. Right, Eeshan, you had a question for you, as in Alejandra read out a question for you. I'm hoping you do remember the question. And could you answer for the participants?
Sorry, Prune, was that for me? Because I was on English translation, and what you were mentioning earlier got cut out a bit. Could you repeat that, please? I have the question with me if that was for me, though.
So yeah, there was a question for you, but let me just read out the English.
No, I can read it out for everyone.
Okay,
And I could answer it.
Okay,
Right.
you've got the one from the text. Cool.
Yeah, perfect. So the question was, the majority of indigenous peoples have a cosmocentric and animistic view of the world, and is this the same as saying ecocentrism? It's an excellent question, and as it's an ontological question, which is what I really appreciate. Ecocentrism, in its very essence, emanates from a philosophy or perspective that places intrinsic value on all living organisms and their natural environment and everything that comes along, as opposed to any other view of the world that treats natural resources or the environment around you as an instrumentality for human population. So from what I understand of cosmocentric, that's one being one with the universe, is in the same vein, is in the same type of thinking, which I think is excellent, and I appreciate that a lot of folks are aware of the distinctions between instrumentalities and intrinsic values. So I think you might be onto something, and I'd love to have a conversation about this going forward as well.
Thank you very much, Eeshan. So I'll go through a couple of other questions, and then you'll be able to also take another 30 seconds for the floor related to your question that you asked about how much land does a man need. Please, you can't leave us on our end. But so Angel, apologies, you had your raised hand for a bit of time. So go ahead with the question.
No worries. Ángel Tuninetti from Genioy Centro de Estudios, a small NGO in Paraguay. And actually, I don't have a question. I'm very grateful of all the fantastic information about the legal aspects. It's just a comment of a worry that we have basically in the countries in which we don't have the sexy tropical forest. And we see that there are extremely biodiverse, rich environments with indigenous communities like the Gran Chaco in Argentina, Paraguay, and Bolivia, the Cerrado in Brazil, that don't get the same visibility as it's here, for example, about their issues, which means that from the perspective of from the legal perspective, from the perspective of raising funds for protection, etc., become kind of second-class citizens in the, let's put it, ecological wars and the protection of the communities that they live in. So basically, I wanted to make this comment because it's something that we have to fight every day, and also the temperate forests of Argentina, Chile. As we speak, they are still bringing down redwoods in Northern California and Oregon, and it seems that they don't occupy in these spaces the same space that the Amazonia, the South Asia, and the Central Africa forests, tropical forests occupy. It's just what I wanted to contribute to the discussion. Thank you,
Angel. Right, I'm afraid that we don't have much time left before the closure of that webinar. So all of the other questions, thank you so much. We'll try to respond separately. Eeshan, do you mind taking 30 seconds of the floor just related to your question that you have asked for everyone to think before I close?
Yeah, absolutely. Thank you again, Prune. I'll make it quick, and I also appreciate Ayman's correction of the question where he made it more gender neutral. I absolutely noticed that. It isn't that it had not occurred to me, but the question that I posed to you was how much land does a man need, which was changed to how much land does a man or woman need by Ayman. Rightly so, but the reason I did not change it to that when I posed the question is because the question itself is very thematic. It refers to the 1886 short story by Leo Tolstoy about this man that is taken over by greed to earn more and more land and ends up with a futile life, losing everything that his greed gave way to. And eventually, the story answers the question, how much land does a man need, by suggesting that all that a man needs is 6 feet of land, because that's all that you go into. So not to end on a pessimistic note, but the idea was that it's best to be guided by one's needs and not by one's creeds, especially when it comes to forests and ecosystems. So thank you, Ayman. In future, I'll correct Leo Tolstoy's topic and include more gender neutral terms. And thank you, Prune, for letting me answer that question, even though I think it would have been fun to let the question linger for longer until our next webinar.
I wish we had more time, and that's the challenge related to those great webinars with the great participation that we just had. So I just would like to close, but really on the behalf of all of the FCI partners. I would like to thank our moderators, so Christina, Ambassador Patricia, Lima, you've been doing a fantastic job, such as you, Antonio, Benjamin, our panelists, Eeshan, Kenneth, Alejandra, and Andrew, and what a great closure, amen, that you have done. Seriously, absolutely amazing. Thank you very much to all of you who participated as well actively. I hope that you enjoyed the conversation. As you will know, the next session is going to be on the 27th of April to discuss the rescheduled topic of reconnecting national and international funding and governance for IPRCs for forest conservation, and also to refine the content for the grassroots toolkit and the policy brief. If it is not done already, please remember to register to receive the links of the Zoom call. Finally, please look out for our survey that I will send you in the next couple of days in order to gather feedback and also some additional material that we could potentially include in the toolkit and the policy brief as we are creating those documents. I thank you so much, everyone, and I wish you all a very good day, and I look forward to our last and third webinar, FCI webinar. Have a great day, everyone.